Hi, everyone. Welcome to the 39th Annual Public Interest Environmental Law Conference hosted by Land, Air, Water. My name is Megan Sweeney. I'm one of the conference co-directors this year, and I'll be serving as the moderator of this panel. I wanted to start by just giving a little tech update / cover some housekeeping things. For starters, do not freak out if you can't see yourself or don't worry, we can't hear you, we can't see you. This is a Zoom webinar. You're only supposed to see the panelists. So just sit back and relax. If there are any legal professionals attending, I'm going to be dropping a link in the Q&A that outlines how to register for CLE accreditation and how to fill out our job form for payment. So be on the lookout for that. And this same link has, it's a document, and it also gives information on how to donate to Friends of Land, Air, Water, which is on our alumni board. They're called FLAW. FLAW supports student stipends for students who are doing unpaid public interest environmental law internships over the summer, and we would love any donation is very appreciated. Also save all your questions for the end. We will be having a Q&A. So just click on that little button at the bottom that says Q&A and put your question in the chat. And yeah, so I'll get started and introduce our panelists. We have Professor Sarah Adams-Shane. Sarah Adams-Shane is a faculty member at the Environmental and Natural Resources Law Center. Her scholarship, applied research and service focus on climate change law and policy, state and local government law, land use, and she focuses on climate resilience in the coastal and inland floodplains and wildland-urban interface. Professor Adams-Shane has been called on by state and national bar committees, private foundations, and government agencies, including the EPA and FEMA, to provide guidance related to coastal resiliency. And then we have Heather Wade. She's a coastal policy specialist and senior planner at the Oregon Department of Land Conservation and Development. In her role, she provides policy expertise, advice, and assistance to local governments, including the Oregon Coastal Management Program and other state and federal agencies. And then we have Christine Shirley. She's a climate change resilience coordinator at the Oregon Department of Land Conservation and Development. She's currently working on and updating the climate change adaptation framework, which is a project you'll be hearing about in just a few minutes. And she has worked at the DLCD for 13 years, and she also works in the county government in California with watershed protections. And with that, I will hand it over to our panelists, and I'll be dropping that link in the chat.
Okay, I'm Christine Shirley. I will start off this presentation. I'm going to spend, see if I get this slideshow to work. I'm going to spend the next 10 minutes talking about or giving you a tour of the coast and some of the coastal hazards that are out there. And then the other panelists will talk about the legal ramifications of that. So I'll get started. Well, I just told you this. And then we're going to, after our presentations, we're going to break back and I'm going to talk a little bit more about the National Flood Insurance Program and some of the other things that DLCD is doing. Okay, so let's take a tour of the coast. So there are many different ecosystems on the coast that provide environmental habitat, recreational, and development opportunities. And this, for the next few minutes, I'm just going to go through each of these habitats or geological features and point out what they are, what their function is, and how sea level rise has a potential to disrupt those functions. So for beaches, of course, we have recreation. Public access is protected by state law, and they provide a function of dissipating wave energy. Many of our beaches in Oregon are cliff-backed, though, and sea level rise has a potential to inundate those beaches and limit public access, completely inundate the beach, and possibly cause erosion of the cliff faces. And then we have sand spits. There are several sand spits in Oregon that most are not developed, but some are. And these sand spits provide important protection for bays. They provide habitat, they have archaeological significance, they provide recreation and sometimes development. And in the photograph on the bottom here, you can see an ill-conceived development on a spit in the 30s and 40s that was eventually washed away. But spits are important habitat and that provide protection. We also have sand dunes. About 45% of the Oregon coast is protected by sand dunes. Some of them are very active, and they both move sand inland and out to the ocean. What's called the foredune protects landward development from wave action, and they also provide important habitat. But sand dunes are subject to erosion and overtopping in a sea level rise scenario, thereby not protecting those homes that were built on top of them or near them. We also have a lot of coastal bluffs in Oregon, and these provide some habitat, and they're also very attractive places, it turns out, for people to build houses. And sea level rise and the storm surge caused by climate change will and is causing erosion of these coastal bluffs and exposing these developed properties to damage. And in fact, just today in the Oregon Live, or the Oregonian newspaper, there is a story about a property in Lincoln City where the seawall fell into the ocean, exposing the building's foundation to damage. So this is not a static situation, it's happening all the time on the coast. All right, another large feature along the Oregon coast are what we call rocky shores. And these are the tide pools that you're often called tide pools. They provide really important habitat, and they're the ocean land interface, as it were, providing food and habitat value for a very particular intertidal animals and plants. And they're a very important source of recreation in the state. Tide pooling is a really popular activity. So these areas are also subject to inundation by sea level rise. And again, they don't have any place to go because they're often cliff backed. And this tendency of being not having anywhere to go because of a cliff back beach is often referred to as coastal squeeze. So if you see that word, that's what it means. All right, we also have tidal flats and marshes. Tidal flats are generally unvegetated, whereas the marshes are vegetated. And these also provide important buffer from ocean waves, really important habitat. And these too are subject to inundation because of sea level rise. And in many cases, the ability of these features to migrate inland with sea level rise is restricted by not only cliffs, but also existing development. Estuaries are really, really critical habitat on the Oregon coast. Some of them are undeveloped and some of them have significant development as shown on the bottom photograph. And the sea level rise and climate change have the potential to change the water chemistry in these areas. More rain in the coastal mountains will cause more fresh water to come into the estuaries. Sea level rise could cause more salt water to move inland. Also, these areas are not generally wet all the time, and so when they become inundated all of the time, they become marshes and mudflats and change the habitat values. And again, these areas do lack landward migration options because of both development and geologic features. Overlooked coastal feature are what are called sand dune lakes. These lakes provide recreation. There's development around many of them. They supply fresh water, and climate change and sea level rise have the potential to cause algae blooms in these areas, in the eroding soils, causing sedimentation and saltwater intrusion from sea level rise. So the chemistry of these lakes is likely to change. And this is important because although by area there aren't very many of these sand dune lakes, they're very unique to Oregon, at least in the United States. And then freshwater wetlands, where the saltwater doesn't come all the way up into the inland, but freshwater wetlands are expected to be affected by sea level rise by way of saltwater intrusion, and also by drought caused by climate change, causing them to dry up and lose their habitat function and fish rearing abilities. And then we have our rivers. And these rivers feed the estuaries, provide drinking water, habitat, and recreational opportunities. And climate change and sea level rise can also affect rivers in that they may be subject to more frequent floods and sedimentation caused by floods and also by wildfire, disrupting the soil conditions and causing sedimentation into the rivers. They can be affected by drought, and also in some cases, if sea level rise is, if the local geological features are promote this, the saltwater lens could move further inland, causing changes in habitat. Then we have some man-made features. Jetties protect harbors and estuary entrances. These can be overtopped, eroded, or sediment piled on top of them. They can be breached. And in fact, the photograph I showed of the old hotel that fell in off the spit, it was caused by a jetty that was constructed, and it changed the way the sand moved in the area and eroded the ground underneath the hotel. So the inundation or breaching of jetties can cause the sand to move in different ways and perhaps cause even more damage. There are many levees on the coast that mostly protect agricultural land, but not always. So we need to have a better understanding of the function of these levees, what they're protecting, and what is at risk if they are overtopped. And I'm on a campaign to introduce a new word to our Oregon coastal management vocabulary, which is polders. The polders are areas that are protected by levees, and there are management techniques that can be used in these areas that we are just now exploring. So Sarah or Professor Adams Schoen is going to talk about some legal issues associated with submerged lands. The state law changes when a piece of property becomes inundated by water all the time. So another legal term that you'll hear later on is this line of vegetation. In Oregon state law, this determines the limit of the public right-of-way on the beach, and it will be instrumental in how what's called a rolling easement that you'll hear more about later are administered. And this is just a graphic to show how a rolling easement would work, that in 1967, the beach was in a slightly different place than it is today. And of course, as sea level rise comes to pass, that will change too. But the issue that we will be facing is that this line of vegetation has a tendency or a potential to encroach into developed areas, which it hasn't done in the past. All right, so there are several adaptation responses, climate change adaptation responses on the coast that you will read about in the literature. Avoid means that we don't build there if we can. Avoid it, we do. Accommodate means that if you do put something there, you make sure that it can withstand the forces in the future of wave action and sea level rise and freshwater flooding. Protect refers to armoring what is already there, and retreat refers to actually leaving the area, abandoning the development there and going somewhere else through a either involuntary, as in the houses falling into the ocean, or voluntarily as say a buyout. And I added a few more adaptation responses that I think don't get enough attention. One of them is to restore connection to those wetlands and estuaries so that the floodwaters and waves have a place to go without damaging the built environment. Communicate refers to making sure that people understand what the risks and potentials are as the climate changes and as sea level rises, so that they can make informed decisions. And cooperate refers to non-governmental organizations and local governments and property owners cooperating to find solutions that benefit everybody, rather than responding as individuals. So with that, I'm going to stop and turn it over to our next panelist to talk about the legal and regulatory implications of these changes.
You couldn't even see me attempting to say sorry just one moment because I had the camera off too. And so let me just get a couple of things to sing to myself slightly. Okay. Let's get this going. All right. So I'm going to start this slideshow, and I'm going to ask Megan, when I'm getting close on time, if you could actually interrupt me because I might not be able to see the chat.
What time, how much time do you want?
Will you let me know when I'm, I don't know, 14 minutes in?
Sure.
Okay. And so can the audience see my presenter view or just the main slide?
We can't, I just see you right now.
Okay, oh, I'm not sharing it all then. Let's see. All right, so just the main slide?
Yes, that's what I can see right now.
So I'm going to just talk a bit about public and private rights in the coastal zone. It's hard for me because one of my favorite topics is really to get more into coastal planning and land use laws. But these are also very important topics for people who are working, to protect Oregon coasts. So one of the things I want to start with, though, this is actually from an article, you know, from February 27th, so very recent. And I wanted to just pause for a moment and let participants read this quote. And actually, in case anyone's attending by phone, I can read it myself. It says, our lifeways are tied to animals, landscape features, cultural sites, important animals such as seabirds, seals, whales, first foods such as fish, clams, crabs, seaweed, and kelp, as well as things just like shells that we use in regalia. And when the state manages those natural resources, they also manage our identity and our culture. And that's a quote from Margaret Corby on behalf of the Confederated Tribes of the Coos, Lower Umpqua and Siuslaw Indians. And I wanted to just start with this because so much of what I'm going to be talking about is really, you know, if we were in a different country, we might refer to it as the colonizer law. We don't really use that phrase that much in this country. But, you know, a lot of, well, I'll just say, we're talking about lands that, you know, mostly, you know, not mostly, we're talking about lands that are native lands originally, and we're talking about stewardship of native lands. Often that talking is coming from, you know, a state or local government, the federal government, an advocacy organization, or in my case, a professor who is themselves not native. And I'll say I have a lot of great ideas, but I don't want to presume, you know, to have that native wisdom about how to really care for our coastal lands. And so, you know, I am going to talk a bit at the very end of this about, you know, some, you know, possible steps and actions that can be taken. And one of those actions is without a doubt listening and elevating the voices that historically and currently in this country we're not listening to and not elevating, which include native voices. You know, along the coast too, there are a lot of recent and first generation immigrants whose voices need to be part of this process as well. So what I'm going to focus on primarily is regulatory takings, substantive due process, public trust, and the common law of property, accretion, avulsion, and erosion doctrines. Now, that is just way too much to talk about between 15 and 20 minutes. So we'll just see how I do here. I'm going to give the briefest overview of regulatory takings that's ever occurred. You know, so one thing I'm going to say is, as it relates to the coast, I'm going to keep it within that focus. So kind of our major Supreme Court cases on regulatory takings. So, you know, Lucas is the case that sets us up for a total deprivation of private property rights, sometimes called a total taking. But it really requires that the taking really deprive the landowner of all economic use of the property. And without that, you're not going to be in the world of analyzing whether a coastal law or policy is a taking under Lucas. And even if there is a complete deprivation of all economic value in the property, if a background principle of state law made the property use that's being constrained, made that use not lawful, then there's not a taking anyway, because a private property holder has no right to do what is unlawful. You know, so for example, I mean, the classic example is that the landowner wants to use their land in a way that's a nuisance. So lingal, you know, is another arm of the regulatory takings, and you know, set of tests, but that requires, you know, that the regulation and you know, require the landowner to accept a physical invasion. And lingal clarifies that without the physical invasion or the total deprivation, like I just talked about for Lucas, then regulatory takings are going to be analyzed under the Penn Central test, which is a 4-factor test. I have the 4 factors on the screen. You know, economic impact on the property, interference with investment-backed expectations, and character of the government action. That's pretty funny. I just said it was a 4-factor test. it's a 3-factor test. So there, I just wanted to say, in terms of coastal regulation, when we look at, there's a couple of things here that I think are important, and one is interference with investment-backed expectation. That requires interference with a reasonable investment-backed expectation. So if you know that you're buying a coastal property, or that you purchased a coastal property, and that it is subject to erosion, for example, you know, a strong argument exists that you don't have a reasonable investment-backed expectation that the property won't be subject to erosion, right? You know, your expectation is that it is subject to erosion. You know, another reasonable investment-backed expectation is that your property is going to be subjected to land use laws, and you're deemed to know what the laws are, but also as an investor, you know that those laws can change, and that a government can, a local government or a state or county, can change those laws in various ways in furtherance of the public welfare. So that the interference side can be, you know, can weigh against the landowner in a takings case, you know, often when it's shown that the landowner, you know, really came to the risk, for example. And, you know, I think it's no longer a credible argument to say that that sea level rise and other climate change related risks like erosion and more intense coastal storms, it's no longer a credible argument to say that those are not part of the knowledge set gained by the buyer. And then the character of the government action, that's also a factor. And so if the character of the government action is to protect the public interest or the public welfare, such as, for example, the public right of access to the beach, or public trust resources, or to protect you know, first responders from having to respond to situations that put their lives at risk, or to protect landowners from injury and catastrophic loss. That's going to factor against the finding of a taking. And so the bottom line result is that most plaintiffs lose regulatory takings cases when they're analyzed under Penn Central. And most beach-related, coastal-related laws that limit the use of property are going to be analyzed under Penn Central. So, you know, and I just wanted to put this up on the screen, right? So I'm talking about the Fifth Amendment of the U.S. Constitution. It's got, you know, it's got the due process clause and the takings clause. And I'm going to say one more thing about takings, and then I'm going to talk about due process. So the Supreme Court jurisprudence, I'm just reading what's on the slide for this one, refers to a special category of land use exactions, which aren't exactly a regulatory taking. I mean, they are, but they aren't. And this is when the government demands that a landowner dedicate a portion of their property, like give up, you know, some of the bundle of property rights, give up a stick, right, as a condition of obtaining a development permit. And the court has created its own separate test for that. And this is, you know, the court describes this as being kind of especially offensive in terms of the giving up of the essential right to exclude. And, you know, the kind of, you know, one of the seminal cases here is Nolan versus California Coastal Commission. And I just want to talk about this case for a moment. Right, so there was a development application to take this small kind of beach shack, you know, I shouldn't call it a shack, I'd probably love to live there, except for the whole hazard issue, and you know, convert it to this larger kind of higher intensity land use home. And so what just happened there? So what was that exaction that the California Coastal Commission asked for? What it required the landowner to give an easement for the building of the home. And the problem with this is that the easement was this easement that ran along the beach under this seawall right here. And really problematically, the California Coastal Commission, I think, just made a mistake because it based the need for the easement on a psychological impact to anyone walking along this sidewalk over here, that with the bigger home, they wouldn't be able to see that there was a public beach over here. And so that would be a psychological barrier to using the public beach. So, the court found that there wasn't enough of a connection between the required easement and the harm that the development was going to create with respect to this right of the public to know that it has access to the beach, because once the big house was built, the public wouldn't be able to see the easement any more than they could see the beach. So they really weren't actually, there was no nexus between what was asked for and the proposed development. And that really was the problem in that case. So to that, I would say, that these development exactions, they can still be used. They're not completely ruled out, such as a public access easement. The thing that I take from this, from the exactions cases, is that there needs to be a clear tie between the development and the harm it's going to cause to a public right, and the required give that the property owner has to give. So, and I wanted to point out too, this is from Justice Kennedy's concurrence in the Lucas case. Coastal property may present such unique concerns for a fragile land system that the state can go further in regulating its development and use the common law of nuisance development and use than the common law of nuisance might otherwise permit. And so that's a reference to those background principles of state law, that even if you have that total deprivation of property, economic property value, if background principles of state law would have otherwise prohibited the landowner from using the land in the same way, then it's allowable and not a taking. Would we have a Supreme Court that would agree with this now? Quite possibly not. But this is the state of the law currently. So, substantive due process, I actually only have one slide on this. And the point I want to make on this is, assuming that a fundamental right is not implicated, right? So I'll just say that, assuming that a fundamental right is not implicated, the question is going to be, and let's say we're talking about local land use law, or a state law also, but we'll keep it local land use for now. Is that ordinance enacted for legitimate public purpose? And is the provision of, is whatever it requires reasonable? And
Professor
really,
Adaptation, you have about 2 minutes left.
Thank you.
No problem.
That's just awful. All right, is it reasonable? So, and it's reasonable. Of course, we know if we're lawyers, when we see things like that, that's a question not about would I do it differently and better, but amongst various possibilities, is this thing reasonable? So with coastal adaptation and hazard protection laws, they're typically not going to run up against a substantive due process challenge. Let me talk. So I'm going to try and keep this to 5 more minutes. If you could let me know, Megan, when that ends. I think I can stay on track. So what about public trust? So public trust in coastal lands and waters. So this applies to submerged lands, submerged coastal waters. If they are tidal navigable waters, those waters are defined by the ebb and flow test, which is the ebb and flow of the tide. But if they're non-tidal, they're still subject to, they're still public trust submerged lands, as long as that water is navigable at law. I'm not going to go into more detail on that right now. So the state holds title to submerged land in trust for the people for commerce, navigation, and fishing, and the kind of list of public trust uses has been recognized as being more expansive to include recreation, environmental protection, although this is a state-specific inquiry. Generally, the governmental power over such land can't be relinquished to others and attempts to do so are void. So, but, here's the but, state grants of parcels of submerged land that don't impair the public trust interest have been held to be valid. There is, however, a strong presumption against conveyance of public trust lands. And so that raises, sometimes questions about, well, what about docks, wharves, navigation channels, harbor improvements? And the question there is that there has to be the grant for such kind of developments has to serve a clear public purpose that's not incidental and remote. And there's more, of course, to this analysis. But one of the things I think that's tricky is, so I talked about, well, if it's navigable submerged, if it's submerged waters that are navigable, then the lands beneath are public trust and the waters held in the public trust. But what about the shore, right? And I think we often hear that, like, in Oregon, the entire dry sand beach is public trust, or, we might hear that about other states, or it's just below, this line or that line. So the federal rule, which doesn't actually really define the state public trust line, so from the Borax case from 1935, that interpreted the public trust line on the seashore in a case involving a federal grant as the tidelands controlled by the state to the extent of the high water mark, right? So that's the mean high water mark right there. So just 1 second. And so most states, and how do we determine that mean high water mark? I'm not going to go into all that detail because I don't really think there's time, but it's an averaging over a considerable period of time of periodic variation. And most states have adopted this rule, but there's a lot of states that have not. So some use the mean low tide line. And I'll just say what Oregon does. Oregon's really, I think, a lot less clear. The dry sand beach is either public trust land or subject to an easement for the public recreational use that's become a background principle of state law. So that create huge implications, though, that those differences in definition.
Professor Adam Shane, you have about 1 minute left.
Thank you.
Okay, you're welcome.
So, I know, I'm terrible. Accretion, avulsion, erosion, reliction. We can really actually just boil this down to a few key concepts. So one is, now we're talking about the common law of property. And this also interplays with how do we manage our, and regulate our coasts. So typically, these landowners that are adjacent to the water, right? They have a right for the water to remain in its natural state, a right to access the water. They have a right to accretions, which are gradual increases in that dry sand, if we're talking about the beach, in that dry sand beach. Gradual accumulations of dry sand, or I'll just leave it at that. They're also subject to reasonable restrictions on their right to warp out or navigate, and they have rights to use the water. But all of these rights require adjacency. So if they lose that status of being adjacent, they lose the rights. And I just wanted to show what accretion, reliction is really about submerged land becoming dry over time. So really that's more often going to be seen in the lake or river context. We're not really going to see that in a sea level rise scenario. But accretion is the describing of gradual additions to the land, which we could see, especially when we have.
Professor Adam Shane, you're out of time.
Thank you. I'm just going to
wrap it up.
It's okay, I don't mind, especially when you have man-made structures. So this is just, so right. So if this is your beach right now, so this is your mean high tide line. That this line represents from here back is private land. But now you have the gradual addition of sand. Now it's from this line back. That, right, so the landowner has gained land as a result of the accretion. The opposite is happening with respect to avulsion, right? If this is or erosion, the mean high tide line moves from here to here. And so the boundary of the private land actually contracts and landowner loses. So it depends whether the landowner actually loses or gains, does depend on whether the event is gradual and imperceptible over time, in which case they do gain or lose, or if it's sudden, in which case they don't. And this just shows, you know, if you're thinking about the tides and the movement of water, how one landowner can be losing while the other landowner is gaining. And this is can be exacerbated and changed by seawall effects. This is also showing how a seawall makes it so that the beach itself ultimately is lost. So, you know, here we have a beach where there was no seawall. And so as that beach gradually moved landward, as the water moved, you know, as sea level rose and the beach moves landward, the beach itself is able to move landward with the, you know, with the increasing water. And so the beach actually continues to exist, but when you've got this artificial seawall, the beach gets drowned over time. So that actually is, I'm done now with the overview of the public and private rights. And I just wanted to show a couple things. You know, this slide is depicting the difference in adaptation costs costs related to sea level rise with or without adaptation from the fourth National Climate Assessment. So this is with adaptation, this is without. And I just want to point out, you know, that our country, especially with respect to flood mitigation, has just a terrible track record, and that track record has really disparately impacted, you know, Black, Indigenous, and other people of color especially. And so this is from the Great Flood, which killed a lot more Black people than it did white people. This is from Katrina. This is actually showing erosion damage on the Oregon coast, a picture I got from surfrider.org. Now this is showing the use of riprap, even though Oregon law limits the use of riprap. There's problems with, you know, kind of loopholes. I'll just say that. This is from Craig Center's website, this photo. Another really significant issue with respect to climate adaptation and resilience of our coastal communities is drinking water and freshwater. You know, so as freshwater resources decrease, if we continue to have sources of pollution, so this is from timber, those freshwater resources in our coastal areas become more and more damaged. And oops, I don't know what that slide is. So these are just some things that we can do, and right, to additional things we can do to protect our beaches. And I'll leave it at that. So sorry for dipping into your time, Heather, but I think we're still on. I think we're still on a good track because
I think so too.
Saved lots of Q&A time.
Yeah, no problem. Can everyone see my presentation?
I can see it.
All right, very good. All right. So hi everyone, Heather Wade here. Today I'm going to talk to you about planning for our changing marine and coastal areas. Today specifically, I'm going to talk to you about some more specific things that the Oregon Coastal Program and the Department of Land Conservation and Development have been working on as it relates to climate change and hazards on the Oregon coast and within Oregon's coastal zone. This includes Goal 18 for beaches and dunes and shoreline armoring, mapping and planning for estuaries, a sea level rise exposure inventory, and then a little bit about the Coastal Zone Management Act and Federal Consistency Authority. First, before we get into those specifics, let's talk a little bit about Oregon's statewide land use program. This program is administered by DLCD and is overseen by the Land Conservation and Development Commission. The LCDC sets broad policy for land use planning in the state. DLCD's primary role is to administer the program and provide technical assistance to communities. Once local comprehensive plans are adopted and acknowledged by the state, local governments they become the primary implementers of the land use program. Additional program implementation takes place through the network of agencies that have authorities related to land use and the protection of natural resources. The land use program is made up of 19 planning goals, of which 4 are coastal specific. Goal 16 covers estuaries and their resources. Goal 17 covers coastal shorelands. Goal 18, beaches and dunes, and Goal 19 for ocean resources. So on to Goal 18. Statewide Planning Goal 18 focuses on conserving and protecting Oregon's ocean, beach, and dune resources, and on recognizing and reducing exposure to hazards in this dynamic environment. Goal 18 is central to the work of coastal communities in addressing the impacts of climate change and coastal hazards in areas along the ocean shore. Of particular importance are implementation requirements 2, 5, and 7. So implementation requirement 2 prohibits development on the most sensitive and hazardous landforms in the beach and dune environment, including beaches, active foredunes, and other dune areas subject to severe erosion or flooding. This requirement has been instrumental in preventing inappropriate development on these critical landforms. It is noteworthy that many of the most problematic current beach and dune management issues are the result of development that occurred on these landforms prior to Goal 18's implementation. The very type of development that implementation requirement 2 now operates to prevent. Implementation requirement 7 specifies detailed requirements for the management of foredune grading. Such grading is permitted in limited circumstances in association with existing development. It must be based on a specific dune system management plan that prescribes standards for maintaining flood protection, maintaining overall system sand supply, and post-grading sand stabilization. There are currently 6 acknowledged dune management plans in place in Oregon, and it should be noted that limited remedial grading to clear sand encroaching on structures is permissible without the necessity for a dune management plan. All right, so related to some of the things Chris talked about earlier, let's see. So on implementation requirement 5, it limits the placement of beachfront protective structures, i.e. shoreline armoring, to those areas where development existed prior to 1977. This policy effectively places a cap on the amount of ocean shore that may be hardened and thus limits the cumulative impacts of such hardening. These impacts include scouring and lowering of the beach profile, which can result over time in the loss of access to Oregon's public beaches. The policy is premised on a basic grandfathering concept, allowing prior development to qualify for hard protection, but precluding such measures for new development. New development must instead account for shoreline erosion through non-structural approaches. An example would be increased setbacks. In the face of increased ocean erosion occurring in conjunction with climate change and sea level rise, limiting hard structures and allowing natural shoreline migration is a critical policy tool for conserving and maintaining Oregon's ocean beaches. Just a reminder, if people forgot or don't know, OPRD is the permitting authority for any ocean shore alteration. That's for both structural and non-structural designs. And they issue permits based on criteria outlined in both their regulatory authority and the requirements of Goal 18. So, on Oregon's Coastal Atlas website, you can find an ocean shores online viewer with an inventory on beachfront protective structure eligibility. This was created by a former coastal management fellow. It's important to note that this inventory is not a replacement for official eligibility determinations, but can act as a good resource. Just some quick statistics for you. As of 2014, 22.5 miles of Oregon's coastline is armored, which is 5% of the overall coastline. 92% of armoring is located in Clatsop, Tillamook, and Lincoln counties. Trends in armoring, these are fairly linear. Repair permits are increasing over time, with exceptions being after severe El Nino winters. 84% of the coast is not eligible for armoring under current policies, and eligible and unarmored lots make up approximately 43 miles of the coast. So, some issues here. Currently, there's no definition of beachfront protective structure in Goal 18. Public infrastructure is not currently eligible for shoreline armoring. There is a critical need for more and better coastal erosion data. And further, there's a need for local oceanfront development regulation. Nesquin's code could be a good example for this. Finally, there are some legal processes for change. This includes a goal amendment, rulemaking, and goal exceptions. All of these have their own unique challenges, and the state does continue to explore these. Rulemaking is likely coming. So now on to mapping and planning for estuaries. Oregon's planning-based approach to estuary management has provided a strong foundation for estuarine resource conservation and development decisions. In particular, the management framework's strong emphasis on advanced decision-making based on spatial planning concepts has proven to be pretty effective in a system-wide approach to management. Likewise, the locally focused nature of the estuary planning process has produced plans with broad-based support and has increased awareness of the relationships between traditional community development planning and aquatic resource management. Most of Oregon's major estuary plans have seen little update or revision since originally developed more than 30 years ago. Despite the general success and durability of these plans, a number of current and anticipated developments indicate the need for modernization and plan updates. In particular, current drivers for various conservation and restoration initiatives and the potential impacts from climate change and coastal hazards are largely unanticipated by current estuary plans. So one attempt to aid local jurisdictions to update their estuary plans with up-to-date and relevant data was and focused on resource inventories. The Coastal Program developed and published the Oregon Estuary and Shoreline Habitat Atlas. This was a project to produce estuary and shorelands habitat mapping information and data using the federally adopted Coastal and Marine Ecological Classification Standard, which we call CMEX. This project covered 21 of Oregon's estuaries. And this information was turned into digital information products and data and put into maps published on the Oregon Coastal Atlas and the Estuary Planning Atlas tool. And these data sets and mapping tools are now available to all Oregon estuary planners and managers, and do provide a fundamental resource inventory tool for the update of estuary plans. So again, estuary plans do require resource inventories, but unfortunately, the data that is used for these plans is severely out of date and also has limitations. In addition, data sets such as the National Wetland Inventory has had its own limitations. But CMEX has now provided us with more up-to-date information on various resources within our estuaries. It also has given us a better idea about the true extent of our estuaries, which has its own implications for both estuary and hazards planning. Something that has not been done by the state, but we are beginning to explore, is actually analyzing where these new data sets conflict with current zoning for estuary management units. And as the conditions and margins of estuaries change over time, there will continue to be challenges for regulating those uses and zoning for both estuaries and their adjacent shorelines. So a little bit about the sea level rise work that the program has been doing. Oregon's estuaries have much development on vulnerable low-lying shorelands. Coastal communities are not really currently planning for sea level rise as a hazard because of a lack of geospatial information. In response to this data gap, we created an exposure inventory to serve as a statewide resource for sea level rise planning in and around estuaries. So as sea level rises, our estuary floodplains will increase in extent. Land currently in the floodplain will be flooded more frequently. Land outside of the floodplain may become part of the floodplain. The exposure inventory determined the assets and geographies most likely to be affected by a sea level rise driven increase in flooding, again in 21 of Oregon's estuaries, and prioritized areas to focus future resources and further study. An exposure inventory is important because it's one of the first steps in sea level rise adaptation planning. For this project, we developed 6 future flooding scenarios. And these were for the years 2030, 2050, and 2100. There is information online about this inventory, both in the form of an atlas, PDF maps for each county, and also a report describing the methods and the results. So as an example, in the 1% annual chance flood in 2100, we found 5 municipal water intakes, 8 wastewater treatment plants, and 58 potential contaminant sources that would be inundated. This is the kind of information that we are hoping to have communities incorporate into their estuary and shoreline planning efforts. In case you don't know, examples of potential contaminant sources include things like large producers of hazardous waste and landfills. So now on to one of my favorite topics, coastal zone management and federal consistency authority. The Coastal Zone Management Act was established in 1972 and provides a flexible framework for coastal states to balance the development and conservation of coastal resources. This is a voluntary program that has 2 primary incentives for participation. These incentives include federal funding for program and implementation and administration, and federal consistency authority. These programs must fit within the goals of the national program, but are implemented at the state and local level. The CZMA provides for broad goals and purpose of the program, and federal regulations outline the rules and procedures for implementation of federal consistency. So while states do have flexibility in how they implement their program, there is specific guidance on how the Federal Consistency Authority is used. So why are we talking about federal consistency? This authority is a coordination tool and provides states with holistic review of federal actions with state policies. This is critical because federal activities cannot proceed without complying with state enforceable policies, what we refer to as a concurrence, when that's a decision when a project actually does comply with all enforceable policies. CZMA decisions are like 401 water quality certifications under the Clean Water Act, meaning that they cannot be federally preempted. So federal consistency applies to an entire coastal zone, to any projects that have reasonably foreseeable effects to coastal resources or uses, and within NOAA-approved geographic location descriptions. In Oregon, we have a highly networked program that make up the enforceable authorities used for federal consistency review. This includes 10 other state agencies and 42 local governments. At the local level, this includes comprehensive plans and land use regulations. So more specifically on federal consistency, the types of reviews that are done are on federal actions, federal permits, and federal funding. Again, this is really designed to promote coordination between states and federal agencies, as opposed to the often perception that it is simply just a veto tool for states. So for federal permit reviews, we review a wide range of types of projects. This includes dock replacements to river gravel mining operations to even really big projects like the Jordan Cove Energy Project. The review process does have to follow federal regulations. A decision must be based on really just two key pieces: coastal effects analysis and an enforceable policies analysis. As it relates to environmental changes, hazards, and climate change, very little empirical analysis has been done on federal consistency under the CZMA, and virtually no empirical studies exist regarding coastal program enforceable policies. However, planning research provides evidence that based on some coastal program structures and reliance on planning as a method for coastal management, federal consistency could be used for hazard mitigation and climate adaptation purposes, and may very well be a critical process over the next century. Hazard mitigation mostly takes place at the local level, and states that employ local policies within their federal consistency frameworks have the ability to incorporate locally specific policies that exceed state standards for more effective hazard mitigation and natural resource protection. While these are potential actions for improvements to CMPs nationwide, it is important to note that coordination among all levels of government is critical to successfully implementing this approach. So what can coastal programs do to adapt via coastal policy? They can develop and implement adaptation plans linked to maintaining water quality of marshes and wetlands, protecting coastal development, preserving habitat, or even controlling invasive species, as long as enforceable policies are put in place with clear standards. So for example, for wetlands, we can prohibit construction of bulkheads, establish rolling easements, or incorporate wetland protection into the planning of new infrastructure. For maintaining sediment transport, we could create policy that prioritizes and incentivizes beach nourishment, remove barriers to sediment deposition on wetlands, and in that specific case, an example here would be levees. And so that's what I have for you today. Thanks for listening. I have my contact information here and some social media handles, and happy to discuss further with you, so feel free to reach out. And I did provide some links to resources here, and I'd be happy to share these with everyone after the panel.
Well, thank you, everyone. Well, I will get started with the Q&A. Our first question is actually, are you all willing to share your slides with people who attended once you compile them all together?
Yes.
Sure.
Okay, sounds great.
Yep.
So I'm going to type my answer in the chat, and my answer is just gonna be my email. So if you would like the slides from today's panel, just send me an email and I will send you the slides. So you should see it in the answered section of the Q&A. Our next question is, how does Oregon's networked program differ from non-networked program under the CZMA?
Oh man, I love that question. So Chris laughs because she knows I love that question. Oregon, the networked version of a program, and Oregon is not the only program in the country that has a networked program, but a networked program compared to a non-networked program would, one of the best examples is California. So California is really run by a sole agency. They have a specific law that governs how they operate and what they prioritize. And that's the California Coastal Commission, which you heard about earlier. They're probably one of the most studied coastal programs in the country. And clearly they go through a lot of legal things. But so that's really the primary difference, is that a sole entity is going to be responsible for a coastal program, and a networked program is going to be, made up of multiple authorities. Now, a networked program doesn't necessarily have to include, say, federal consistency policies that are at the local level. Everyone has their structures just a little bit different. And then sometimes even other networked agencies in a coastal program may not actually contribute to federal consistency review, but may have other permitting authorities that are associated with coastal management and development.
Heather, I'd like to follow up on that. Your experience with coastal management in different places. What do you think are pros and cons of a network versus a one agency kind of under one roof approach?
Yeah, so I definitely agree that there are pros and cons to each method. Ultimately, I think that it really depends on, how, for example, how formalized a networked program is. From the networked program side, things that are good is that, the workload might be distributed more, depending on whether or not you have that local component to the program. You might get more geographic focused policies that are, again, more favorable for successful hazard mitigation. And if you have a networked list of authorities, then your state doesn't have to develop new law. With California, they had to go through the process of developing their Coastal Act, and as the sole entity, they have a lot on their plate. And so I think, those are some examples. That this is actually something that I'm studying for my dissertation, and so I hope to have a more definitive answer to that question in a couple of years. But I'm curious what others think.
So moving on to our next question. The next question is, when will the estuary management plans be updated? And is that initiated by the DLCD or other local governments?
Oh, goodness. So that's a really good question. There is a specific initiative going on in Coos Bay right now. It's been going on for the past several years, where they've been trying to update their estuary management plan. I believe that the local jurisdictions, they're hoping to start the adoption process within the next year. You know, generally capacity is part of the issue in getting that done, and that's including, you know, just like workload, but also funding capacity, because it, you know, it isn't something you can just do without funding in these small rural coastal communities. As far as like the coast-wide estuary management plans, we don't have a timeline. For our current strategic plan for 2021 to 2025, we have a strategy on estuary planning, and so our hope is to work with communities to really understand what is available to them in terms of data, identify what the barriers are for planning, for doing these plan updates, and, you know, kind of creating a scope of work on how to get them from using an outdated plan to updating their plan with the best available data. We also have a couple of other projects that are starting up now. So for example, we did receive a grant award to update the Yaquina Bay Estuary Management Plan. And so that's exciting. And then we're trying to supplement local efforts by utilizing another grant from the National Fish and Wildlife Foundation to work on estuary plan updates, but with a focus on resiliency, specifically looking at hazards and climate change vulnerability. So it's a really big effort. I'm actually putting together what I'm calling the Estuary Plan Roadshow. So it's going to be really focused a lot on outreach and engagement. And as part of that, we're also developing a plan evaluation protocol so that we can actually help communities evaluate their plans, figure out what the weaknesses are and where they maybe should focus their update efforts, so that it takes a little bit of the burden off of them.
So then our next question is, how often are CZMA consistency determinations appealed? And if you have seen any consistency, oops, sorry.
I just
Have
shared
you seen
something.
any? No
Sorry.
problem. My screen just shifted and I couldn't read. So I'll say the question again. How often are CZMA consistency determinations appealed? And have you seen any consistency appeals be successful?
So I think, Heather, it's probably directed at you, but since I had this in my documents,
Sure.
I'll share it and give you just a break for a second.
Sure.
So NOAA actually publishes on its website CZMA appeals lists, and then calls out in particular energy-related appeals. This is through April 26, 2018, so it doesn't, it doesn't show, for example, the Jordan Cove appeal. But so of all CZMA appeals, so in the way the CZMA appeal process works is that, if the state objects on consistency grounds, then the Fed, with respect to projects where there's an applicant, the Fed can't grant the permit or the license to proceed. And so then there'll be the appeal process is to appeal to the Secretary of Commerce, which is really delegated to NOAA, to get that overridden. And so that's an administrative appeal. And then that decision can be appealed in court, to a court. So, of the 45 that are listed in this document, 31 of them, at the administrative appeal level, the decision was not to override the state, and 14 were to override the state. And there's a very specific criteria also for overriding the state. And then this breaks it down also by oil and gas, natural gas, and liquefied natural gas. Some of them are just handled on procedural grounds. There's a strict timing with respect to appeals and whatnot, or many of them are withdrawn or settled. So I'll just set that up. And Heather, if you want to say more, since you just went through one of these appeals.
Yeah, no, I mean, I think that was a really, really great summary. I would just note that the Jordan Cove appeal that was, recently, that the Secretary of Commerce recently decided the outcome for, that's the first appeal that Oregon has ever had. And so, and you can see here, since the program started, there really are not a lot of appeals. But yeah, so the state has only had one.
Which was upheld.
Which was upheld, yeah.
And the burden is on the federal applicant. So like in the Jordan Cove context, the burden is on the developer at the appeal stage. And since there's a lot of deference too, when, to the administrative decision, if, on that decision to override or not override, it gets much more challenging for the appellant in, when that administrative decision is appealed to court.
Yeah. And the only other thing that I would add, and sorry if you actually just said this, but something else that I find really interesting about the appeal process is that outside of the procedural grounds, the real, criteria for the review is to weigh the national interest of a project against the adverse effects to coastal resources and uses. So for example, the Department of Commerce does not go in and they don't weigh in on an enforceable policy analysis, but they do use the coastal effects analysis to inform their review. And I always thought that was kind of an interesting component of the appeal process.
So on that same note, we have a follow-up question that says, how about challenges to a positive state consistency finding as opposed to a state objection?
I don't think there's a I don't think there's a right there. The administrative appeal is only for the applicant.
So I will give an example. I'm trying to remember the case. I'd have to go back and find it, but there is case law for Alaska. When Alaska had a program, they concurred to a project for federal consistency, and I think it was an NGO filed suit against the state because they did not enforce an enforceable policy that was directly tied to a permit. And so in that instance, that seems like a major consequence of giving a concurrence maybe when you shouldn't have, or when there are other authorities within your policy framework that come into play.
So then our next question is, what role can insurance play in reducing investment in high-risk coastal areas?
I think that's a me question. So the flood insurance is only provided by and large by the National Flood Insurance Program, a federal program. There is some private insurance out there, but on the coast, it's very, very hard to find. So in the past, National Flood Insurance Program insurance has been priced too low for the risks based on the coast. And as a result, the National Flood Insurance Program is rethinking how they are rating flood insurance policies, both on the coast and inland. It's called Risk Rating 2, Risk Rating 2.0. You can look it up. But what the basic gist of it is that they're trying to make the cost of insurance reflect the risk that is faced better than the old method did. And as a result, we are going to find that insurance on the coast is going to be a lot more expensive. Flood insurance on the coast, a lot more expensive. And time will tell whether that cost increase will discourage further development on the coast. But right now we don't have any data because insurance has been so cheap that relative to the risk that people just buy the insurance and build in risky places.
So the next question is, on the North Coast, we are very concerned about how industrial forestry is threatening water quality and quantity. And now PSU is reporting that the forestry pesticides are showing up in our clams, oysters, and mussels, which are already stressed. Are you studying the impacts of the current forest practices on our coastal shores?
DLCD is not.
Yeah, so that's another good question.
Mhm.
And there actually have been a lot of discussions at the state recently about the coastal non-point source pollution control program and the efforts for that the state is taking to actually get approval for that program. Forestry, I believe, is actually has been conducting studies in cooperation with university researchers on some of those issues that were part of the disapproval of that program. And that, you know, that is about all I know. And I think that there is, continued efforts for coordination between ODF, DEQ, and DLCD.
Yep.
To address those issues.
Yeah, I would just add, I mean, and when I put my slides together, I highlighted those slides with, timber practices related runoff, and our technical person behind the scenes here, Bryn Catt, a student, wrote on this issue last semester in my ocean and coastal law class. I think my experience also working with DLCD recently is that there's a move to get Oregon's non-point program approved by, at the federal level, and that it's going to have to address timber practices. And really, I would say that's part of our climate resilience and climate justice responsibilities.
Okay, we only have about 8 minutes left and 4 questions. So the next question is, there are many very small communities along the coast that will have a lot of difficulty doing comprehensive environmental planning work. Is there any possibility that regional or county coordination can be done? And could that include the working on risks associated with having the only transportation corridor being Highway 101, which we have recently seen is at risk?
Well, this is Chris. I will try to answer that. We do the best we can to facilitate the getting grants to help local communities. Some of them are administered by DLCD and some of them are given directly to the coastal communities. But we do recognize that capacity at the local level is a real roadblock to climate change adaptation planning. So I'm going to put a pitch in here. Right now, the National Flood Insurance, or excuse me, the FEMA, Federal Emergency Management Agency, because of disaster declarations in the state over the past year, has given the state $70 million to spend on natural hazard mitigation. And the grants can be used statewide for all kinds of mitigation projects. And if anyone listening to this is interested, they really should get in touch with the Office of Emergency Management, because the window for applying for that money is coming up in April, the deadline. So, or you can call me and I'll tell you how to get connected with that opportunity. $70 million is a lot of money to be spent statewide. And I'd hate to leave any of that money on the table. And it can be used for planning, local planning.
So the next question is, oh, I'm sorry, Mr. Adam Shane, do you want to weigh in?
Well, I want to say, there's been a question about insurance and some reference to the NFIP. And, one of the things that every chance I get, I do try to talk about this, that the NFIPs, the federal regulations implementing our National Flood Insurance Act, the act says to FEMA, originally had, doesn't matter, to the implementing agency, to adopt regulations that create minimum standards that local governments or the state have to adopt if they're going to qualify for the insurance under the program, and that those minimum standards have to be minimum standards that incentivize the movement away from hazards of development. And the agency did not do that. There are only two standards that have to do with where development occurs, and one of them is that development doesn't occur below the mean high tide line. So we'll go figure. And the other is really that it doesn't occur in the channel of a river, practically. So they're just really meaningless. The standards allow for development, and even the most hazardous coastal flood zones, they focus only on building resilience. Can a building withstand a flood event or a hazard? And not on community resilience, not on whether or not the building should be there, right? And couple that with outdated maps and not looking at the future life of the building in terms of hazard assessment, but instead looking backwards as if the building existed in the past. It's just a mess. But this is regulatory, so we're talking federal regulation needs to be changed to make these regs comply with the National Flood Insurance Act, which required the movement away. But as long as that federal regulation isn't changing, and maybe there is a window of opportunity to see that change happen, but a state like Oregon with a natural hazards goal could go further than those minimum standards. And unfortunately, what we've seen, interpretations of our natural hazards goal is that it's sufficient to comply with those minimum standards, right? So what I'd really love to see now that we are getting a lot more focus in our state on climate and climate mitigation, climate resilience, and climate justice is looking at that issue. It's amazing to hear about this potential grant opportunity, or grants opportunities. And we're also close on time, and I know there's some questions pending, but I wanted to give a couple plugs too. There's so much that students and advocates could do. You can sign up to receive notices from DLCD on CZMA and on various things that are going on. You can submit comments. There's legislation going on right now. There's a hearing on Monday on a climate justice bill. So there's a lot of organizations that you can be volunteering with. Craig Lawsoner, Oregon Shores in particular, they're doing fantastic work on the coasts. You can volunteer with them. You can work for them. You can give them money, right? 1,000 Friends does coast work too. Surfrider, of course. Beyond Toxics is behind that climate justice bill. NAACP is doing a lot of great climate resilience or climate justice and environmental justice work. So there's just a lot of opportunity right now, especially I think in the state of Oregon.
Yes, and I would also add that for people looking for careers in this area, helping cities and counties apply for FEMA grants is a big opportunity. The grant actually will pay for your time if the grant is awarded, but the capacity of local governments to apply for these grants is very low, and they really, really need help. And the state does not have the bandwidth to give the support that we want to.
Yeah, and I just saw a plug for Oregon Coastal Alliance in the Q&A, and I would just say, to the extent I missed really great organizations, and I'm sure I missed more, I would recommend going ahead and typing those in.
We're just about out of time for our panel. Thank you all for coming, and thank you to our panelists who put a lot of time into creating this panel. It was really engaging and fun. So we have a panel happening again at 5 tonight. It's called Green Hydrogen, or sorry, 5:30, Green Hydrogen and Grid Resilience. If anyone would like the link to that panel or the link to our brochure in general, just ask for the link in the Q&A and I'll be happy to send it to you. But thank you all for coming.
Yeah, thanks everyone. And you can send me emails. I'll answer questions about this subject.
I'm just putting resources up on the slides for anyone who's still sticking around. Yeah, it was fantastic. Thanks my fellow presenters. And thank you, Megan. I know you put so much work into this.
Yeah, we started planning this, I think, fall of my 1L year.
Well, that pandemic, it can really throw a wrench into things. All right. You can, do you want me to close my window now? I can do it.
Sure, I think I'm going to give it 1 more minute and then I'm just going to end the Zoom call. So it doesn't seem like anybody is asking for links.
Yeah, there was one question, a BPS part of its policy for climate adaptation. I don't know what they mean by BPS. They may have already left.
They mean beachfront protective structures.
Oh, beachfront protective structures.
Yeah.
Yeah, that's all part of our Goal 18 regulations. So to the extent that if the building was built before 1977, they may qualify. If not, nope.
Well, Chris, I have a question for you. Did you get kind of what you were wanting from my overview of some of the background like private and public rights laws?
Yeah, so we're in the process of writing a sea level rise planning guide, and we are trying to put in one place some of the considerations that local governments need to be aware of. And a lot of planners on the coast are not seasoned planners, and they may not be totally aware of the whole ball of wax, as it were, with respect to common law and regulations and, you know, court cases and so on. So yeah.
Yeah, I think for that, it would be helpful to find an Oregon case for each point. Yeah. When it's Oregon related. One thing that I've noticed in FEMA guidance materials for planners and local government municipal officials, the takings rules are sometimes misstated. The total taking rule, I'll go back to that slide because it's, here it is. You know, total deprivation rule from Lucas is frequently misstated as if there's a total taking, you know, if there's a total deprivation of the economic value of the property, then compensation is owed, leaving out that subpart, which is unless the regulation is prohibiting a land use that's prohibited by other background principles of state law. So if, you know, if it's prohibited by nuisance law, or if it's prohibited, you know, because it would interfere with, you know, a public right to beach access, or something like that, you know, then the property holder doesn't have the right in the first place, because you don't have a right to use your property in a way, you know, that does those things. And so since you don't have the right, then the DLCD regulation or the local government regulation isn't a takings.
Yep, and I think the investment-backed expectations is really important too.
Yes.
And that's why we want to beef up our information sharing, mapping, and so on.
Yeah, and the character of government regulation, and this also goes to the question of substantive due process. Local governments or any level of government needs to make a clear record, oftentimes in findings, of the harm that they're preventing through the regulation, and the benefit that they're, you know, conferring, right, the public welfare benefit. You know, and the court will hypothesize, but, you know, make it so much easier if it's there, if it's clear, and if it's a land use regulation, tie it to the state goals and the comprehensive plan. It doesn't have to be to survive a challenge, but it's helpful.
Yeah, you just gave me a great idea for another chapter in our sea level rise guide, which is how to write findings.
Yeah,
around
it's a
these
good one.
issues.
Yeah, and
Yeah.
right, and how to deal with, yeah. And just for me, I'm like, we have to start planning for the lifetime of the development and consider more than just the building. You know, a development is a community. It's got streets, it's got, right, all these, it's got people living.
Yep.
Yeah. It's exciting that you're writing that. I'm happy to provide any thoughts or, response or feedback if you want it.
Great.
Someone is asking if you could put the contacts back up on the screen.